afternoon, everyone. Because of my overdrive and adrenaline, I will sit down today and present, just for the ease of my presentation. And my structure of my presentation, essentially, I will deal with addressing how the ISA works. I think pretty much Solang has covered that. And particularly how it violates the fundamental rights of a citizen and how the courts have been excluded from judicially reviewing ISA detention, and also how the ISA as a piece of legislation is also immune from constitutional challenge. It's not only Section 8 and 10 that, when Solang mentioned Section 8, ISA is excluded from judicial review, but also Parliament went one step further up into the Constitution and meddled with the Constitution. Is Article 149 of the Constitution, and I will address all the troubling features and how, as a result of that, there have been a fundamental violation of our civil liberties and where violations of various articles which are supposed to guarantee our constitutional rights have been seriously violated. Having said that, in the course of the spate of constitutional litigation that I have witnessed, I observed that there is a slight move in judicial attitudes towards the recognition of the courts to perform the role of a guardian of the Constitution. I'm not overly impressed by the fact that there is still a deferential attitude towards the political organs, as in the legislature and the executive. I mean, I'm saying deferential, the courts playing a deferential role, not in the sense that they are biased deliberately, but I'm saying that there is, there's more leaning towards Parliament and what legislature has intended, unless in very, very extreme cases that they will be, very ridiculously extreme cases that they'll be prepared to strike out legislation as unconstitutional, which they have not done. And that optimism comes from the recent recognition of the two cases, which I will highlight later, of the recognition of basic structure of the Constitution. And that will be very relevant also to understand the intense moment that we are witnessing, especially with the Constitutional Commission's recommendation on the changes to the elected presidency. Now, history of the ISA, I will skip. So long we have done some emergency regulations, PPS, so this is the problem of not communicating with each other, but it's fine. We are used to that. Now, I would just highlight, beside the ISA, we also have the Criminal Law Temporary Provision, CLTP, and that was legislated in 1955. That's also preventive detention without trial. Now, the courts have recently are prepared to do judicial review in Section 55 as in the CLTP cases compared to ISA preventive detention. So there is actually a progressive move towards that end as far as CLTP is concerned. Now, the misnomer and anachronistic nature of CLTP is that it's supposed to be criminal law temporary provision. How on earth it's temporary since 1955? Only it's possible in Singapore. Okay, the ISA in modern Singapore, Solang covered 8.1. But what is significant to note is the role of the president. Constantly, the president's name is mentioned everywhere conveniently. The president does not have personal discretion in this matter and must follow cabinet's advice on the matter. But it's like the president must be satisfied. But it's actually the cabinet must be satisfied. This is why we get all the time confused. We got a shock when we were doing the case of Yong Wee Kong, and it was supposed to be a presidential pardon. The then Attorney General, Mr. Walter Woon, in court said that in theory it's the president, in practice it's the cabinet. Then I took out a constitutional application to actually find out who's actually exercising, presidential pardon. We all go to the Istana, we bow down, we cry, we plead for mercy, you know. In the end, we find out that actually the president has no power. It's the cabinet. We should be going to Oxley Rice. I don't know, it's no more on there, sorry. Okay, never mind. That's for another day. So, the thing is that always the president is satisfied, actually it is the cabinet. Even for example, you know, in all over the world, clemency petitions are usually exercised by the head of the state, you know, governor, general, and sultan in Malaysia, as well as, you know, queen and so on and so forth. In England, it's a bit peculiar because of, you know, English history. The thing is, only in Singapore, it's the cabinet. And it's highly conflicted. That even that role, you know, I mean, that clemency is the only thing. You don't even give clemency in the first place for umpteenth years. But that little role also, you don't give the president that power. He has only the power to kill, to sign the death warrant, but not to give life. You know? Okay, there are some rights the detainee have under the ISA. The detainee must be informed on the grounds of detention as soon as possible. The detainee must be informed of the facts upon which the detention order is based. However, the authorities need not release information that is against the national interest. In fact, the advisory board, all the information does not have to be presented to the advisory board. A lot of information can be withheld, and that's also problematic when it comes to actually making representation. And the detainee makes representation to an advisory board, not to a court of law. And therefore, the constitutional rights are not guaranteed in terms of how one presents to the advisory board compared to one's rights that can be secured if one is presenting oneself before the court of law as an open court. Now, the advisory board provides the Article 151 provides that the president to appoint all the members of the advisory board reviewing a person's detention. These are the members. Someone who's qualified to be a Supreme Court judge, 2 other members who are chosen after consultation with the Chief Justice. If the advisory board under Article 1514 does not recommend a release, the president has no discretion to order the release. See, it's significant that the president's name is mentioned several places, you know, and gradually his powers are clipped. And the advisory board, these are the problems that we have. It is seen by the public as not being independent, and it is completely unelected. The reason why I'm mentioning is unelected, particularly in this situation whereby, you know, ISA is already so draconian and so arbitrary, but there needs to be some sort of transparency, some sort of check because of the nature of the arbitrariness. So an elected body with certain public accountability would be preferred compared to one which is completely unelected and opaque. And again, if the board agrees with the cabinet, the president is completely powerless. Now, what are the violation of the fundamental liberties that has taken place since the 1987 Operation Spectrum, and which this legislation was instituted then after 1988 Teo Solong's case when she was released. And I still can't believe that you can actually overthrow the army and the government and everything, you know. They've elevated you as so powerful. So Article 149 confers the legislature powers to make laws contrary to the fundamental liberties of the person. And Article 149 has this particular clause. It's a notwithstanding clause. What does this mean? This means that any legislation against subversion is immune from challenge from constitutional argument using Article 9. Article 9 is guaranteeing personal liberty, life and liberty. And for example, if you are detained unlawfully, for example, you know, due process, that to have an open court hearing and you should be given advance notice, whether you have a right to counsel, all these will be elements of questions of life and liberty. So if those issues are engaged or violated, if if an ISA detention violate Article 9, which would be ordinarily unconstitutional, will become constitutional. What will be illegal is legalized. Not only we immunize the judiciary from judicial review, but also we legalize illegality. Go figure. And Article 11 is, it guarantees, in fact, there's supposed to be no retrospective application of criminal law. No retrospective application of criminal law means if a law is passed today, it should affect prospectively whatever actions that one is, comes in breach of that particular law, it should affect you in future, but not retrospectively, because they changed the law to arrest all of them back, because she already had the benefit of the court releasing. So they passed this law so that they can retrospectively arrest you and keep. And this is really, really an anathema, a contradiction of its height. You can never have a retrospective criminal law. No jurisdiction can think of a retrospective criminal law, but this is there. I mean, this is Article 9 supposed to protect us against a retrospective application of criminal law. So if it's inconsistent with that, that is tolerated. Then you have Article 12, equal protection of the law, where if you are treated unequally, for example, one person is given less detention, another person is given longer detention, one is a greater security threat, and all these things, if you have any information of that sort, you cannot go and complain, because unequal treatment is tolerated. And Article 14, guaranteeing freedom of expression and speech, that if it violates your right to speak in terms of your freedom of expression, whether it's religion or anything of that sort, that is also, if there's a violation of that article, freedom of expression, if it's inconsistent with Article 14, that would also be, would come under the notwithstanding clause. So this is the problem. The Constitution is like a mother. She wants to, it's a mother. We must have that sort of respect and sanctity. Can you imagine how this Constitution have been brutalized, have been meddled with? It's a super constitution within a constitution. I will revisit this later. And this is what happened after the 1988 arrest. I've addressed this, what detention without trial, how it violates fundamental liberties guaranteed by Part 4 of the Constitution, and how judicial review, exclusion of judicial review take place. Now, can the courts review the president's satisfaction that a person poses a risk to Singapore's national security? For example, this person who's arrested, if he does not pose a national security threat, and if he's under arrest, can we challenge that? The answer is no. What is this? Battery is low. The answer is no. It's communicating. So the background to this is Operation Spectrum case, and the case of Cheng Zuanzi. Where is she? Famous case of the seminal decision of Cheng Zuanzi was where the court, this case is very famous for its pronouncement on the rule of law and the legal limits of political power, and it reaffirmed that the court had the right to examine the exercise of discretionary power of ministers and other administrative bodies. And so this case also led to the release of the detainees. So then, the Court of Appeal, in fact, imposed a objective test as opposed to a subjective test. Subjective test means if it's in the opinion of the president or the minister, it is that discretion cannot be challenged, which means that even if there are irrelevant considerations which are not related to national security, you cannot challenge. That means it's period. I've decided, you cannot challenge that. That is subjective test, and that was the test in 1971 that was held when there was a spate of what you call ISA arrests. It was only in Ching Zhuangzi in 1987, along with Teo Solang and the rest who appeared in the Court of Appeal, that the court said we will have to look objectively, not subjectively. Objective test, do you have evidence? In fact, they have to look, they have to patrol the four corners, the parameters of the detention order to see that whether you are within the confines of what Article 141, the subversion laws, have allowed you to exercise. And then the Court of Appeal released the ISA detainees in 1988 after this decision, and Parliament quickly had series of constitutional amendments that were targeted at reversing the impact of the Ching Zhuangzi's decision. And as I mentioned before, they had introduced the notwithstanding clause under Article 149, and it restricted judicial review in ISA cases such that the courts could only examine whether detention orders were made procedurally valid. Things like whether there was a president's signature and so on and so forth, just the procedure, not the actual reasons behind the detention, and whether there was an element for national security where the court can review. After the constitutional amendments were made by Parliament, Ms. Teo Solang challenged the amendments in the High Court. And what is very crucial is that for the first time, in 1971 it was briefly touched, but in Teo Solang's case, the basic structure of the constitution issue was visited. The basic structure is this: if there are some things in the constitution which is very basic, which are like fundamental liberties, separation of power, the judicial authority being supreme, the judicial authority being the supreme authority to review all issues as regards to the constitution and so on and so forth. I mean, the executive, legislation, judiciary, the separation of powers, the courts have the power to check the limits of the executive and the judiciary, and so that, you know, everything is within the confines of within the limits of power, legal limit. So that is basically the basic structure of the constitution. It cannot be altered. And if it's altered easily with a 2/3 majority, like what we have here, then the basic structure is disturbed. Question is whether with 2/3 majority, can you amend anything in Singapore? Except one with, 2/3 majority in Parliament, you can almost amend any part of the Constitution except about national sovereignty. In some aspects of the fundamental liberties, you need national referendum. So basically, in this Ching Zhuangzi's case, the ISA would no longer be unconstitutional, even though it was inconsistent with Article 12 and Article 93. This is a contrast to the previous case in Ching Zhuangzi's case, that it will be unconstitutional if you take away the judicial power. Article 93 is where the judicial power is vested. It's basically separation of powers. In fact, what this amendment have done is that whatever the court did in 1988, they have legislated in Parliament these laws to give an interpretation which was in 1971 a subjective test. So Parliament has legislatively overturned the decision which was made in Ching Zhuangzi. And not only that, immediately they abolished appeals to the Privy Council in ISA cases, and also in the counsel who was representing Teo Solang, Lord Lester, he was also barred from entering Singapore after the High Court case because he gave some lecture somewhere and said something about Singapore and his permit. I think he was not allowed to come to Singapore. So judicial review in Singapore has been replaced by a non-judicial institution like the elected president. And these institutions are extremely weak. Currently, the presidential candidate must meet some selection criteria before they are allowed to stand for election under Article 19.2. This assessment is also made by the Presidential Elections Committee, and they are all generally affiliated to the government. So how much, the EP also has no say over cabinet decision making with respect to defense and security measures pursuant to Article 151A. So, you don't have proper judicial review, and then you also have some review with the elected president, which the institutions are so weak, and this is really, really the extreme sense of how the ISA is, continue to exist in Singapore. Now the debate continues. Do we have a constitutional or parliamentary supremacy in Singapore? Is our constitution supreme or parliament is supreme? No. It's only in England the parliament is supposed to be supreme because they have no constitution. In England they have unwritten constitution. So in America, in Singapore and India or even Malaysia, we all have constitution. What is the difference between constitutional supremacy and parliamentary supremacy? Constitutional supremacy means you can't willy-nilly amend the constitution. That means certain features of the constitution is something that if you amend, the courts will step in and say that, look, you cannot amend. For example, what they did in Teo Solang's case, Article 93, which vests the judicial power of the court, they took that power, said that you cannot have any judicial review. That's a breach of the separation of powers because the executive has intervened in the judicial powers. So that alters the notion of the basic feature doctrine of the Constitution. So therefore, if you constantly can amend the Constitution with two-thirds majority and you also exclude judicial review, so this was the point that was raised in High Court in Teo Solang's case by Lord Lester before he was not permitted to come to Singapore because then, before the case went to the Court of Appeal. So the thing is that in India, for example, this doctrine, the case of Kesavananda received the notion of basic features doctrine in India, that the courts in India said, look, there are some things so basic, like what? Free and fair elections, fundamental liberties, equality provision. These are all very basic. They said with a two-thirds majority, you cannot amend the basic structure of the Constitution. You can't even amend, with national referendum, that part, we don't have to go that far, but basically the courts are the guardians to ensure that the basic structure of the Constitution is not disturbed. To that extent, there is constitutional supremacy, and that is how it is supposed to be. Because Article 4 of the Constitution, Article 4 of the Singapore Constitution assert the constitutional supremacy of the Constitution. Now, the courts in Teo Solang's case in the High Court said, look, Article 5 of the Singapore Constitution basically does not put any limit on Parliament. So you can basically amend the Constitution. And the courts did not receive this doctrine of Kesavananda. Now, the Chief Justice Sikiri in the Kesavananda's case stated that the principle of separation of powers, the democratic form of government, and the principle of free and fair elections were basic features of the Constitution. Why they are basic features? It preserves constitutional supremacy. It protects the democratic and constitutional order of the country. Now, so that is the position until now. Now, recently, in the case of Muhammad Faisal, the former Chief Justice Chan Sek-Yong held that the principle of separation powers is part of the basic features of the Constitution. Now, after 1988, more than 2 decades, the court in this case, for the first time, they're coming back to the recognition of the basic feature doctrine. And in Yong Wee Kong versus Public Prosecutor, this case which I argued in 2015, challenging the constitutionality of caning, whether caning is a form of torture, inhumane and degrading treatment, although that application was dismissed, what was recognized was the right to vote was arguably recognized as a basic feature of the Constitution. If you remember the case of Velama, the Hagong by-elections case, in that case, the court have recognized the right to vote as a right. Before that, there were questions as to whether it's a privilege because the right to vote is not in the Constitution, clearly defined. So there were debates. Of course, the law minister said that it was a right in Parliament, but it was not as crystallized so clearly as a constitutional right. So the courts have, in fact, brought this right to vote into the basic structure of the Constitution, which means the court is slowly moving they are moving progressively towards recognizing the basic feature doctrine. Now, if a challenge is presented on the ISA in future, this point is still open for argument, because the point on basic feature was decided only on the High Court in Teo Salang case. When it went to Court of Appeal, it was not addressed properly. And now these 2 cases have visited and crystallized, brought back the notion of basic feature into the Constitution. Now, the basic feature is also a issue in the current elected presidency, the amendment. If you look at some part of the amendment, it does, in terms of selecting minority and so on and so forth, it does have some implications. It does engage this principle as well. Now, this is the recent detention of Zulfikar, which I will leave it to James. Any hot potato issues, it's all James. Teo Salang and myself are here to, no, we are not here to fix you, don't worry. Fixing is somebody else. Okay, and do recent detentions show that the ISA is effective and relevant? There is still potential for abuse of the law because the courts have very little power to monitor the decisions of the cabinet and the president. There's no open trial. It's very difficult to communicate. If there's no open trial, all the extremist elements and all that will come to open court, and that could be challenged. So that would be a better process. In fact, if you are worried about all your national interest issues are, thrown out in the public, and that should be preserved in the name of national interest, those matters could be held in camera. They can be held behind closed doors, some aspect of the evidence. And there are better practices in other countries. And why the ISA should be abolished? For a very simple reason, Malaysia has abolished it. And Malaysia also, if I'm not mistaken, they have also abolished the criminal law temporary provisions. Their version is some PP, whatever, law. And, okay, then I will, Solang has talked about the Terrorism Act. Okay, that's all for now. Thank you.